All right, we are on the record. Anything further before we bring in the jury?
Yes, Your Honor. At this time, the defense has already invoked the rule of sequestration, and that rule is being violated because the state is talking to witnesses.
I don't recall it being invoked, but you're invoking it at this time?
Your Honor, it was invoked in the motions in limine that when the proceedings began, and it began when we started picking jurors, that the rule of sequestration be invoked.
Okay, all right. So are there any other witnesses that are present?
Yes, Your Honor. Ms. Evelyn Bethel is present. She is outside the courtroom. And as far as invoking the rule of sequestration, we would just ask that the victim remain in the courtroom until tomorrow's law.
Where is the alleged victim? Okay, you're Gregory Bethel, sir?
Yes, ma'am.
Okay, all right, bring in Evelyn Bethel, please.
Your Honor, I also need your officers who are witnesses as well.
I understand. I want everybody in here. Thank you. All right, good morning, ma'am. What is your name? Okay, all right, so Evelyn Bethel is here, Gregory Bethel is here, Detective Tiffany Rogers, not here, Officer Joseph Taylor.
Present.
Hi, sir. Good morning, Officer Kenneth Ramos.
Present.
Officer Brandy Bunker. Officer Michael Perez. And John Oldfields. Okay, so the witnesses that we do have here, please listen carefully. The rule of sequestration has been invoked. What that means is that during the trial, you all will not be permitted to be in the courtroom and listen to the trial. You will be waiting outside. You will only come into the courtroom when it's your time to testify. We do have, I think we do have clear masks for everyone. We do have clear masks for everyone. So as you come in like that waiting area between the doors, you're going to be given a clear mask before you take the stand to testify. Please change your mask, put on the clear one before you get on the stand. Also, if you remain outside before or after you testify, the rule of sequestration prohibits you from discussing with each other anything about this case, anything about what was testified to in the courtroom, anything about the trial. So please abide by that. If you don't, that could cause a mistrial. And of course, we'd have to start over again. And I know that no one wants that to happen. In addition, there would be other sanctions for violation of that important rule. So with that, I'll ask everyone to please step outside. We are going to begin trial at this time. And that is with the exception of Gregory Bethel. Okay, Jaime, please bring in the jury.
We want to confirm that one of the witnesses is one of the officers. I don't believe that as long as it's under.
You just heard, I did a roll call.
Yes, I know, and that's why I was referring with
What's the name?
Michael Perez, Officer Michael Perez.
Okay, Michael Perez was not in the courtroom. Is he in the building state? Sir, you have to speak up because I don't want to have to keep asking you to speak up all day.
Officer Perez is not coming on.
Okay, all right, there you go.
Your Honor, also wanted to address the court regarding Officer Bunker. I know the defense wanted to adopt our witness list. At this point, the state is no longer interested in calling Officer Bunker to the stand today. So can she be excused?
Defense, can Officer Brandy Bunker be excused?
No, Judge.
Okay, no, sir, she cannot be excused.
And defense has listed Michael Perez as a witness and subpoenaed.
Okay, so he's under your subpoena?
Yes.
Okay, well, I mean, he's under subpoena, so he needs to be here.
And if the state has information as to why he's not here, they should be sharing it with the court because they cannot excuse him without our permission or the court's order.
Well, I would think the state didn't excuse Mr. Or Officer Perez from another subpoena. I mean,
I'm just going to confirm our subpoenas that were sent, but at this point, I believe we never subpoenaed Officer Perez. However, I'm going to confirm just real quick, but we never subpoenaed.
did either of you have a telephone conversation with Officer Michael Perez in the past few days regarding attendance at trial?
I did, Your Honor.
Okay, and did he happen to mention that he had two subpoenas, or?
He did not mention any subpoenas, but he did mention he wouldn't be able to come to court because he was on vacation and there was also some other time he was on vacation.
Okay. Okay, well, do you happen to have a phone number for Officer Michael Perez?
I believe I do, Your Honor.
Okay, and what is that phone number?
(305) 979 3131.
All right, I'm calling Officer Michael Perez on my cell phone. It's on speaker.
And forwarded to an automatic voice message.
What's the date the subpoena was served, defense?
9793131 is not available. At the tone, please.
Good morning. This is a voicemail message for Officer Michael Perez. This is Judge Elisabeth Espinosa. I'm calling you from the bench on the record during the trial of State of Florida versus Marquita Munnings. My understanding is that you were served with a subpoena to be here this morning, and you are not here, sir. Please return the call to the prosecutor. What is your phone number, sir, for the officer to return the call?
The phone number is 754
281 5706. And defense, what's your number? 786 416 3254. That last phone number is the phone number of the attorney who has you under subpoena. Please call them back immediately. Thank you.
And Your Honor, the subpoena was served on.
Okay, so, but that's where we're at now. So he served with a subpoena. He served June 4th, but it sounds like he may not be here today. I don't know where he is. The last information we have is that he's on vacation. So what says the defense? Do you want a moment to talk?
Yes,
Yes,
please.
And Your Honor, just to confirm, the list of the officers that we subpoenaed were Sergeant Rogers, Officer Taylor, Officer Bunker, and Officer Warren. And during motions, and then we also discussed we also had discussions regarding defense adopting the state's witnesses. And it was made clear that we're not under any obligation to subpoena an officer if we don't intend to call them.
And that's okay.
And we
You
did
didn't
not.
have to subpoena them. They did subpoena the officer, and the officer should be here because it sounds like he was served with a subpoena. So we'll be off the record for a few minutes. I'll give you all a few minutes to discuss. If you need it, you need it. And then I'll ask you how you want to proceed, okay?
Thank you, Your Honor. If you just step up.
Yes. We're off the record. We back on? All right. We are back on the record. Defense, what says the defense regarding Michael Perez? I don't know if you all had a chance to call him or talk to him.
Good morning again, Your Honor.
Good morning.
The defense's request is that the court enforce the subpoena. This is a witness that is essential to our case. We subpoenaed him in good time. He never called our office. He never said that he was going to be on vacation. The state was aware that he was going on vacation or was on vacation. He never said anything to defense. Had it not been for the court calling out the names of the witnesses and us catching it, we would not know that he was not going to be here. We're asking that the court enforce that subpoena.
Okay, well, as you know, there's a process to that. So for purposes of today, it seems like Officer Michael Perez is not going to be here. You know, we'll go through the process. You're free to file whatever requests or motions, but at this time, what I did ask was Ms. Baez to go out there, maybe see if the other officers are able to get in touch with Officer Perez, so at least we can hear from him and see exactly if he's really out of town or maybe he's in town somewhere. I'm not sure if he's on, away from town or he just has a day off. And then if you could bring in Sergeant Tiffany Rogers, so I could advise her regarding invoking the rule. Jaime, can you ask Sergeant Tiffany Rogers to come in here?
Yes, sir. I did step outside your direction. I asked your officer to get any contact information. The one only officer that spoke up, the other one was not really know, said he's on vacation.
Okay, like on vacation, I guess, like they seem to think he's out of town. Okay. All right. So Sergeant Rogers, good morning, ma'am. I just wanted to let you know that the rule of sequestration has been invoked. So that means that you're not going to be permitted to sit and watch the trial. When you're out in the lobby, please don't discuss anyone's trial testimony with them. Please don't discuss the facts of the case. And that is all. I just wanted to remind you that the rule is invoked at this time. Thank you so much. You can wait outside. Okay. I mean, at this time, this officer's out of town. I'm not. What are you asking me to do? There's not much I can do.
At this time, we're asking the court will continue this case and give us the closest trial date to when Officer Perez will be back in town.
So that's going to cause a problem because we have only 6 jurors right now. And the chances that those 6 jurors can come back on a future court date is a gamble. Maybe they can, but I don't know. What says the state?
Of course, Your Honor, the state strongly objects to any continuation in this case. As you've mentioned, Your Honor, we only have 6 jurors. We already picked the jury. The defense the state is not under any obligation to make anyone available for the defense. The defense had the jeopardy was attached. If defense wanted to
Jeopardy has not attached.
If defense wanted to inquire into whether the availability of the officers, they could have done so on their own time. Okay. Just because they did not do what they were supposed to do, our victim is here, our witnesses are here, all officers are present.
I understand. So jeopardy has not attached, but I'm not inclined to grant the continuance at this time. We've picked the jury. I understand you all subpoenaed this person. Maybe next time you'll follow up a little bit more and figure out where the person is, make sure they respond to you. But I'm not inclined to grant a continuance at this time, so that motion is denied.
Your Honor,
Anything
if
else?
I may-
Yes.
If I may reflect the record, and proper, also that this is an essential defense witness. We placed him under subpoena. He is a police officer, an arm of the state. We placed him under subpoena well in advance of the trial. The subpoena was served on June 4th. Right now, we have no information as to when it was that he went on vacation and how it was that he went on vacation. What we do know is that he was served with that subpoena on June 4th.
How was he served?
E-service. E-service is the method that is used in this jurisdiction, and it is the custom that it is e-served. And when we make those subpoenas, it is looked at as far as vacation time and all of that. That was not there at the time that that subpoena went out and was served on him. Now, in the meantime, I just want to address this, that the state attorney who has full access to this officer knew this information. And while they may not have had an obligation legally to say anything, they certainly had an obligation morally to say something, that this officer was not available and was not going to be here, because they were the ones that was able to speak with him. It is a known fact that police officers do not speak with defense unless, of course, it is with the state attorney's office. So us having equal access to this officer, we do not.
Okay, well, you know, you all, I hear that. So I'm not in the business of making moral judgments. My jurisdiction is limited to making legal findings. And, you know, this goes back to my point that I think I say at least once every calendar. You all need to speak to each other. You all need to communicate. You know, if it is a witness that's under the state, pick up the phone, call the prosecutor. They're going to talk to you and ask the question, hey, do you think you can reach out to this officer? So, I mean, I say it all the time, but you all need to communicate. I understand all of that. But this isn't the first time that I've, you know, we've had a situation where someone is subpoenaed and it turns out that they weren't available and they don't show up. So, you know,
under normal circumstances, Your Honor, I would probably be inclined to say that I fully understand what the court is saying. But I want to call to the court's attention the case of Espinosa versus Dade at 943 Southern 2nd 1001 is a second DCA case decided in 2006. And it stands for the premise that it is error to deny a continuance when subpoenaed defense witness fails to appear.
okay, well, let's take a look at this case. Do you have a copy with you?
I do not, Your Honor. Did not know this was going to be an issue today.
Nine four three, 7/2, 1001.
I don't think I wrote down the citation correctly. Give it to me again, please.
Certainly.
7/2, 1001.
Okay, yeah, I wrote it down now. Thank you. You know what? Let's go off the record, Alejandro. All right, we are back on the record. Defense counsel has moved to continue this trial because they have just discovered in court on the record in the presence of all of us that Officer Michael Perez of the Miami-Dade Police Department is on vacation. And you all have cited the following case that provides the court some direction regarding how to proceed, which is Ostalaza versus State at 943 Southern 2nd, 1001. So, defense, I have a few questions for you. First, excuse me. when did the defense first list Officer Michael Perez on the witness list?
Your Honor, while this is the motion that I've made, this is Ms. Sarah Alvarez's case. I'm gonna let her give you those dates.
Thank you.
I'm gonna state let's have that information.
No,
Or
it's
just
fine.
let Ms. Alvarez.
It's fine.
Okay.
I'm gonna hear from Ms. Alvarez, then I'll hear from the state. So the question is when defense first listed Officer Michael Perez as a witness.
Defense first listed Michael Perez as a witness on February 25th.
Okay. And the subpoena went out presumably a few days before June 4th of 2021, and it was served via e-service on June 4th of 2021.
That's correct. When this case was originally set for March 1st, we subpoenaed Officer Perez at that time because the case didn't go, the subpoena was canceled, so we subpoenaed him again on June 4th.
Okay, so let's talk about that. So the subpoena was served for this trial June 4th, and you had actually subpoenaed him one time prior for a
Correct.
previous trial setting, which was on what day?
The previous trial setting was on March 1st.
And what is the day that the officer was served with the trial subpoena for the March 1st trial?
I believe it was the 26th
Of
of February.
February 26th of 2021. Okay. Other than listing Officer Michael Perez as a witness and serving the officer or having the officer served with these subpoenas, what else did defense counsel do to ensure the presence of Officer Michael Perez?
Yeah. I may be able to speak to that. A part of our process is that our support staff has a listing of days off for the officers, has a listing of any vacation time that's put it into the system prior to sending out a subpoena. Those subpoenas go out with that knowledge and that information so that we're aware and we can make representations to them.
So if, for example, you see that an officer that you want to have be present is on vacation a particular day, you would know at some point prior to trial that you need a continuance because that officer shows that he's on vacation on the day that you need the officer.
Exactly. And Your Honor, just so that you are aware as well, we've tried speaking with officers. We are always told that we would have to go through the state attorney's office in order to do that.
Well, did you all go through the state attorney's office?
We had no reason to believe we needed to go through the state attorney's office. We had subpoenaed this officer one time before. We subpoenaed this officer this time. In addition to that, in the subpoena, it says that if there is a problem, to contact our office so that we could make arrangements. None of that was done either.
Okay, so the subpoena does include the phone number for your office?
Exactly.
Okay.
And the attorney of record that is subpoenaing the officer.
So in this particular case, do either of you have personal knowledge of the fact that this schedule was consulted, that this schedule in fact did not show that Officer Michael Perez was on vacation today?
Your Honor, we followed the process where the secretary verified that information, sent the subpoena. She confirmed to me that she had sent the subpoena, so I would be able to confirm that is our process. So.
Okay, yeah. Who is that secretary who did that? Okay, you can give her a call, but not right this second. So defense, you mentioned that I don't remember how you characterize this witness, so I'll just ask you, why do you believe that this witness is important? What do you believe that this witness's testimony will be? Go ahead and proffer that.
Right, this was the officer who came to the scene the night of the alleged incident. This officer had body-worn camera footage. This officer spoke with the alleged victim on the very night that this incident happened. He was essentially the first officer on the scene. He was the first officer to make observations. He did 2 reports in this matter. He is essential because he was the first responder on the night of the incident itself and made reports in reference to it.
Did this officer speak with your client at any point?
No, Your Honor. It may have been at some point, but on the night of the incident, he did not.
Was your client still on scene when Officer Michael Perez arrived?
No, Your Honor.
Okay, so I'm not understanding why this person is so essential.
He's essential, Your Honor, because he is the officer who was there on the scene.
And I'm sorry, let me rephrase the question. I hear you, but the question is substantially, what this case instructs is that defense would have to proffer that substantially favorable testimony for the defendant would have been forthcoming. So let me phrase the question that way. So what favorable testimony for the defense do you believe that Officer Michael Perez is going to testify about?
Officer Perez is going to testify in reference to injuries, in reference to, which is a central part of this.
Injuries to who?
The alleged victim.
Okay.
In reference to evidence that was not collected but was provided afterwards by the alleged victim. We believe that this officer is essential because he would also be able to speak to the state of mind of the alleged victim in references to things that we should discuss with the court before: child support, DCF payments, and
okay, so let me stop you because it's very specific. The case law you provided is very specific, and it asks what is the favorable testimony that would have been forthcoming. So how is injuries to the victim favorable when your client is charged with a battery? How is that favorable to your client?
The lack of injuries certainly is favorable for us.
Okay. And what about the state of mind of the alleged victim? What do you believe that the officer is going to say regarding that that's favorable to your defense? I'm asking you to proffer essentially what you believe the officer is going to say.
At this time, we've got the alleged victim in the courtroom. I ask that he.
Okay. So, I agree with that. Mr. Bethel, sir, go ahead and for these legal motions and these legal rulings, please wait in the lobby, sir.
Yes, ma'am.
Thank you so much. Okay, Mr. Bethel has exited the courtroom. Go ahead.
Your Honor, in the body-worn camera footage that is there, there's a wealth of information that is helpful and favorable for the defense. We could show Your Honor, the video itself. We certainly don't want to try our case prior to trying our case, but this officer we cannot even introduce that body-worn camera without the officer being present and the conversations and the evidence that was there.
Okay, so you believe an essential part of your defense is this body-worn camera video and the interaction this law enforcement officer had with the alleged victim is going to be favorable to the defense in your case?
Yes, Your Honor.
And you're not able to introduce the video, obviously, if this person does not appear in court?
Exactly.
Okay. The third prong is that the witness was available and willing to testify. So, willingness to testify, let's address that first. I mean,
Your Honor, he's an officer of the Miami-Dade Police Department. part of his job responsibilities when he goes out and investigates a crime scene or a crime that is alleged to have taken place is to come into court and give testimony.
Right, yeah, this is an officer, so this is a unique situation. That's why I addressed that first. That's not an issue here regarding the officer's willingness to testify. And then the witness was available, given the context of the facts of this case, that reference was available at some point. I think that takes us back in this situation to point one, which is the assistant checking the list and ensuring that the officer's schedule did not reflect that the officer was on vacation. And lastly, that the denial of the continuance caused material prejudice. So I'll allow you to advise the court at this time. Please tell me how this would cause material prejudice to your client.
Because, Your Honor, it takes away an essential element of what we would be showing as far as our defense, and that is that this was fabricated at some point, that it was self-defense on another point, and that this was all orchestrated by the alleged victim because of his motive of trying to get out of paying child support and gain custody of the child.
And in order to put forth this defense, you do not believe you can do it without this officer?
No, Your Honor, we do not believe we could do it effectively without this officer.
Okay. State, what is your response?
Yes, Your Honor. I'm just Duran on behalf of the state. Your Honor, do you just want to hear one response, or do you want us to go by the prongs?
Sure, you can go by the prongs.
Okay. So for the first prong, prior due diligence to obtain the witness's presence, Your Honor, the reason we file trial certification forms for a reason. In that form, it states defense had good contact with all their witnesses. That was checked off 3 days after the subpoena was sent to that officer. So they ensured essentially that they had good contact with the witness and that he was willing to come in. That substantially favorable testimony would have been forthcoming.
And I'm so sorry to interrupt, sir, but I'm trying to multitask because we have a jury outside. So if possible, if one of you could be emailing Yanira Sastra while the other one is listening to Mr. Duran's argument. Go ahead, Mr. Duran, thank you.
Yes, Your Honor. And also in that this case represents that it was the only sole witness in the case that was cited by defense counsel. In the case at hand, our case, defense counsel's witness list has 6 witnesses. And it's this case that was cited is only one sole witness. Denying motion to continue the jury trial when this sole defense witness failed to appear despite being subpoenaed for trial. Here, this is different as it is more than one witness. In addition, Your Honor, Officer Perez was not the only one who went to the scene the night of the incident. Officer Taylor also went to the scene the night of the incident, and he is here present to testify. Defense counsel is more than free to inquire about the victim's injuries or lack of injuries through the cross-examination of such witnesses without having to get into that testimony through the officer. In addition, Your Honor, yesterday during motions in limine, you indicated that body-worn camera would essentially be hearsay. So I don't see how they would introduce any relevant body-worn camera. And if they do get through the hurdles of admitting it, then they can do so through Officer Taylor, who is here, who was also present the night of the incident, as Officer Perez was not the only officer who went to the scene.
Okay, let me ask you about that. Is there another officer that could introduce and that could serve to authenticate the body-worn camera that defense is referencing?
So during motions in limine, defense counsel cited 2 officers Perez body-worn camera and Officer Taylor's body-worn camera, since they were both there the date of the incident. We do not intend on using any of the body-worn camera, but Officer Taylor is here if defense counsel does want to try to introduce any portions of the body-worn camera of Officer Taylor, as he was also present on the premises the date of this incident. Okay,
but you agree if they wanted to try to introduce any body-worn camera of Officer Michael Perez, they can't do that. They cannot authenticate that body-worn camera without Officer Michael Perez.
That's correct, Your Honor. They would have to go through Officer Taylor's body-worn camera, who was also present.
Okay, and has Ms. Yanira Sastra been able to confirm, or does she have a copy of the list that she checked, or can she at least confirm that she did check the vacation schedule.
I'm just writing the details so that she'll know exactly what it is that we need, and then I'm gonna send this out to her.
Okay. Okay, so we'll be in a brief recess. We can go off the record. Are we back on?
All right.
We're back on the record. I'm going to go ahead and call Ms. Christine Herrera and just ask her some questions regarding the scheduling of the officers. And for the record, this is related to the first factor the court should consider when a motion to continuance is made at this juncture of a case.
Good morning, Public Defender's Office. Christine speaking. How may I help you?
Hi, good morning. This is Judge Elisabeth Espinosa. Is this Christine Herrera?
This is she. Yes. Hi. How are you?
Good. How are you?
Doing well, thank you.
So you're actually on speaker on the record in open court. We're in the trial of State of Florida versus Marquita Munnings. I just have a couple questions for you. Did you send out the subpoena for Officer Michael Perez for this trial?
I did not personally. However, one of my partners, who's a secretary, she sent out the subpoena initially. It went out on June 4th, and it was acknowledged
Okay,
by the
and
officer.
did you all have an opportunity to view that officer, to view a schedule that told you whether or not that officer was on vacation today?
Yes.
And was there any indication that Officer Michael Perez was on vacation today?
No, it actually reflects in CGIS, his working hours from June 14th on. He is a midnight officer. However, his preferred court days or deposition days would be Monday and Tuesday in the morning. And our system did not show any conflict, nor did he acknowledge with any conflict.
Okay, thank you so much, Ms. Herrera. I appreciate it.
You're welcome. Have a great day, Your Honor.
You too. Bye. Okay, so I guess, was everyone able to hear that?
Yes.
Okay. All right. So at this time, based on the hearing and arguments of counsel, the court is granting the motion to continue. At this point, so that I'm going to just excuse this jury. Okay. You know, the jury was told that trial was going to be this week, and they actually have not been sworn. That's for, you know, due to the pandemic reasons, which those are thankfully dissipating at this time. But this jury actually has not been sworn. That's going to be changing in the future. We can talk about that, but that's kind of where we're at now. Either way, this is a defense continuance, so speedy trial is waived, which I'm sure it was waived a long time ago. I realize, Ms. Munnings, you've been waiting for your trial for a long time now. So I'm not going to ask these jurors to come back. You know, really, I think so. The administrative order from the Florida Supreme Court opens things up more. The last week of June is when we would be permitted to have more than one trial at a time. They're not going to be a very happy jury, I predict, if they have to come back. So I am going to thank them for their service and release them at this time. And we will have to pick a new jury for this case. Is there any objection to that from the state?
Yes, Your Honor, the state does have an objection, and I just want access to the record, if
Go
possible.
ahead. Sure.
Your Honor, just going back to the prong, for prior due diligence, other than sending the subpoena as inquired by Your Honor when speaking to the secretary, the state would just inquire as to what else has been done. When we send our subpoenas and based on the trial certification form, it states defense had good contact with all witnesses. Your Honor, when we send subpoenas, we ensure that the subpoena is served. We call we email, we make sure we wait downstairs for them to come up and we wait with them. Also for prong number 2, substantially favorable testimony would have been forthcoming. Your Honor, defense counsel indicated that they think the testimony would be favorable to their case. That is not enough. It needs to be substantially favorable to their case. For prong number 3, the witness was available and willing to testify. I would just inquire as to what further steps, other than sending an e-notice that says it was acknowledged, what further steps have been taken. And the denial causes material prejudice. It would not cause material prejudice due to the fact that there are 5 other police officers here, one who was there at the date of the incident. We have the victim that can be cross-examined based on his injuries, his lack of injuries, anything about DCF reports or anything about child custody has been ruled irrelevant and would open the door in any sense. So we believe that defense counsel has not met any of the 4 prongs, and it is not an or, it is an and, which means all prongs have to be met.
Okay, so I understand I have made my ruling. My question for the state was, do you have an objection to releasing this jury and picking a new jury?
No objection.
Defense?
No.
Okay. Please bring in the jury.
I can agree, please.
Good morning, everyone. You can have a seat, please. So I'm gonna just want to make sure I can see everyone. Actually, I'm gonna remain standing so I can see you all. So there, first of all, you all have been extremely patient. I know that you all were on time and that you've been waiting since before 9 a.m. this morning. There has, due to a legal issue with the case is being continued at this time. And I'm releasing you from your jury service. Your jury service has now concluded. And I thank you very much for your service. This was unexpected. We didn't foresee this, so we weren't really prepared. You may hear from my office on your email. We do want to acknowledge and thank you for your service and provide you with your juror certificate, which shows, in addition to the paperwork you all can download from online, which shows that you have fulfilled your jury service. We're very grateful. I think a lot of you were looking forward to participating in this process, and we all appreciate that very much. But Again, due to some unforeseen circumstances, the trial must be continued at this time. So thank you so much. And with that, you are all released and you're free to go. Thank you. Thank you all. Bye, guys. Okay, the jury has exited the courtroom. Anything further from the state?
Yes, Your Honor, just 2 points. One, I'm just requesting that our victims and witnesses be put on be placed on standby for the next trial date due to the fact that they've been here. So we're just asking for them not to have to be able to check in, whether it's in person, Monday, if we're just picking juries, and just for them to be present when they're actually testifying.
Okay. Ojo, do you happen to have the schedule of trials so I can give everyone a new trial date? Thank you. If you would like, just bring everyone in so everyone can be here to hear the trial date.
Also, Your Honor, the victim is present in the courtroom and just does want to be heard pursuant to Marcy's law after Your Honor says new trial date.
Okay. Give me one moment. I have to pull up a couple calendars to give you all a new date. Well, does anyone know when Officer Michael, so I see everyone is in the courtroom. You all can have a seat if you please have a seat. So I do want to address all of the witnesses who have just entered the courtroom to let you know that this case has been continued. And I'm going to give you all a new date. Apparently, you can ask, you know, defense or the state to explain it to you, but the case has been continued. Does anyone know when Officer Michael Perez is returning from vacation? No? I appreciate the heads shaking no, because when I say anyone, I did mean like anyone at all in here. Does anyone know? No. So I see a lot of heads shaking no.
If I may identify from that state, the victim of the opportunity to be heard on this continuance and just pause it.
Okay, I've made my ruling on the continuance, so I will hear from you, sir, but please have a seat. I have other matters I must address first. Okay, I would like to reset this case for June 28th, but I'm actually not sure. Every time I give a date, I feel like it's wrong. We have to consult with a lot of calendars. The schedules are all over the place. We're obviously in transition. You all have read the administrative order. I think, well, actually, no, I really don't. No. So June 28th or June 30th is the first week that we're going to go forward to trial without having the pre-qualification the week before. and we'll receive our jurors directly from jury pool at the Dade County Courthouse on that Monday morning. I'm speaking out loud because I think I confused that with thinking that all 3 divisions would be in trial starting that day. I don't think that's the case until July, right, Ojo?
No, I can look into it.
Huh?
I can look into it.
Actually, you know what? This 6, 7, 8 here, it's right here on this schedule. So it looks, I don't know if this is correct, but according to this schedule, Division 87, 88, and 89 each have separate trial days as pre-pandemic, beginning the week of July 6th. So is everyone available for trial? This is Division 89, so it would be the week of July 6th, but it might not start till July 8th. So here's the deal. It seems simple, but it's not. There's a lot of divisions. As some of you may know, I mean, I know the attorneys know, but so you all understand, the judges in this domestic violence division, we have criminal calendars, we have civil calendars. So there's a lot that needs to get moved around. We're in a transition from going to, pandemic orders to, non-pandemic now. So it's difficult to give you all a specific day. What I can tell you is the week of July 6th. I'll say that for now. I will get with all of the people that we need to consult with in order to figure out what day that week exactly the trial would be or could be. And they'll get back to you right away. But let me ask this way. So the week of July 6th, are any of the witnesses present in court unavailable, meaning on vacation that entire week of July 6th? Anyone out of town July 6th? I see one hand. And that hand belongs to who? Sergeant Rogers. Okay. So Sergeant Rogers, you're out of town the week of July 6th? Okay. And State or Defense subpoenaed Sergeant Rogers to be in trial for this case? Okay. All right. So how about, is anyone out of town the week of July 12th? Anyone? I don't see any hands. So the week of July 12th, everyone, yes, ma'am. Back on the 13th. Tuesday?
Yes.
Okay. In the like afternoon? Will you be back at work on Tuesday, or will you be returning from vacation on Tuesday?
I'll be back to work.
So as of Tuesday morning, you'll be back?
Yes.
Okay, great. Thank you. So no one else has an issue the entire week of July 12th, which I'm pulling up the calendar. That is Monday, July 12th through Friday, the 16th. Okay, so, and that includes a counsel, and Ms. Munnings, are you available as well? Okay, so I'm going to try to ensure that this trial is set for July 12th. I'm going to set it for sounding. So of course, I'm very equivocal because of the reasons I've explained. But if it's fine, that's when it will be. The sounding will be, this is Division 89, so the sounding will be on June 29th, and the trial July 12th that week. And those are the new dates. We'll follow up to confirm that, okay?
Just a question.
Yes.
Is this going to be like special set that it's number one, or will it just be on the trial list and we'll see where it falls?
Well, I'll follow up to confirm all of that. Thank you. So, okay. All right, and Mr. Gregory Bethel, sir, you would like to address the court. Please stand, approach the podium. Good morning, sir. Please face the clerk, raise your right hand and be sworn.
Testimony about to be, the whole, nothing but.
Okay. Good morning, sir. What would you like to tell me?
Good morning. How you doing?
I'm doing well, sir. Please raise your mask over your nose. Thank you so much.
I don't know. It's not too much to say. First off, I would like to thank all the officers for being here, my counsel and you and everybody for doing their job, because we've been doing this for like 3 years now.
Okay.
I'm hoping that the next time we come here, because this is not the first time that they've had to continue for whatever reasons, it gets addressed. It seems like every little hiccup, we're trying to avoid the situation. And I get calls saying, oh, well, you can't talk about this, you can't bring about this. So in my opinion, it's become very biased to their side. And that's fine. But hopefully next time when we come, we don't hear anything about a jury problem or somebody didn't make a phone call or whatever the case may be. My biggest issue is that I haven't been able to see my daughter unless it's on Miss Money's time. She's had a restraining order. When she wants her to come, she comes. I haven't seen her in the past 2-3 months. That's really what all of this revolves around. So at the end of the day, this could all end if I can have a relationship with my daughter and that relationship wasn't encroached.
Do not listen to me. Sir, stop.
Stop,
sir. Can you not hear me? I said to stop. So I should have told you this ahead of time. If you are going to address the court, I am the court. You address me. Do not turn around, not one more time, and look at Miss Munnings, please.
Yes, ma'am.
If you have something to tell me, I'm listening. But if this is an excuse to try to speak to Miss Munnings in open court, then please have a seat.
Absolutely not.
Okay, so what would you like to tell me?
Like I said, this whole debacle has been about the exchange with my daughter. I don't know if some people in here have kids. If somebody asks you how your kid's doing, you can tell them. I can't. So if I'm frustrated or angry, that's where it's coming from. I don't want to hear about phone calls that haven't been able to be made. I don't want to hear about anybody's time. I don't want to hear about anybody's traveling. I don't want to hear about anything. Everything that I had to do for whatever reason, whether I had to be to court, whether I had to call 5 courthouses and be on the phone for 20, 30 hours, lose sleep, I had to do whatever I had to do. Everybody needs to get it together. We're all adults. We all need to be responsible, and we need to be accountable for whatever we have doing. So I'm really hoping that we come here and we don't make another excuse and it gets drawn out. Because if the strategy is to wear me down, that's not gonna happen. That's not gonna happen. Okay. So we can do this dance until we're blue in the face. But this is me regaining control of my life. And I intend to do that. As far as my daughter's concerned, I got the paperwork for the custody. So I'll be turning that in. We'll be establishing paternity, and that situation will be dealt with regardless. But that's where I'm at. I want to have a 5-minute conversation with my daughter without Ms. Munnings encroaching on that. Everything else, it doesn't matter to me at this point.
Okay, and I understand and I appreciate how frustrating that must be, and I'm sorry to hear all of that is happening. I do want to make sure and give you this piece of information so we're all on the same page. I have no jurisdiction over any time sharing or child care. The only issue I have jurisdiction or authority to address is whether or not is to conduct the jury trial, to preside over the jury trial. If it's not even me making the decision, it would be a jury to determine whether or not a battery occurred by Ms. Munnings against you on or about July 22nd of 2019. That's the only issue that's going to be addressed by this jury trial. The issues regarding the child, and I'm sorry to hear that. I realize that must be extremely frustrating, but I do want to make sure and give you that information so you understand that as the judge presiding over this trial, I have no jurisdiction over the time sharing of your child. Okay.
Like I said, I just hope when Mr. Perez comes back in town, he comes and saves the day. I really hope in their favor. I don't want to hear any more excuses.
Yes, sir. Anything else?
That's it.
Thank you, sir.
Thank you. You said you have again.
Your Honor, while all parties are present, we're asked that the court would just address the situation where Ms. Munnings is under a stay away order and that Mr. Bethel not make any other
Mr. Bethel, sir?
to contact her.
Sir, you were not excused. Please have a seat. One moment, sir.
And while, Your Honor, I understand that Mr. Bethel is not under the court's jurisdiction as far as the stay away order is concerned, we're asking that, you know, since it is to be a shield, that he use it as a shield.
So I again, taking everyone back to the vacuum that I am in and the limited vacuum I have jurisdiction over, I am not aware of whether there are other court orders and there is a child involved. So I'm not going to advise anyone of anything that is not a court order within my jurisdiction. So that's that.
Exactly right, Your Honor. I'm not asking you to address anything outside of your view. Your purview is that you have a court order that orders Ms. Munnings to stay away from Mr. Bethel, which she is wholly complying with. And we're asking that we're putting the court on notice that he is constantly trying to contact her while she's trying to stay under the court's authority and not cause her to be in contact with him so that she then becomes under this court's jurisdiction all over again with something like that. We're asking that stop.
Right, and I have no authority to instruct him of that. I realize this is a complicated issue. There's a child involved. There is, you know, if there is some sort of, I don't know, state, do you know if or defense, does anyone know if there's an injunction in this case by either party against either party?
There is no injunction in this case. There's also no custody agreement.
Okay, so.
It's only the stay away order from this court.
Okay, so that's the only order.
And then she's trying to be in compliance with.
What I will say, Mr. Bethel, I'll just say this, you know, if Ms. Munnings doesn't speak to you, sir, it is because she is under a court order to not speak with you. So I'll just remind you of that as part of this case. As long as it's pending, there is a stay away order from you that was issued at the beginning of the case that prevents Ms. Munnings from going within 500 feet of you, where you live, work, go to school, anywhere that you might be. It prevents Ms. Munnings from having any type of contact with you at all, direct or indirect, no phone calls, texts, emails, messages on social media, sending messages through third parties. So that's another piece of information for you to have, I guess, so you understand that Ms. Munnings at this time is prohibited from doing those things, okay? All right, so anything further from the state?
Nothing further from the state, Your Honor.
Actually, I apologize, Your Honor. Good morning. That's why on behalf of the state, being back and forth, Your Honor, as far as with regards to the child, I actually just asked Mr. Bethel if he would like to be able to modify the stay away order so they can have telephonic communication with regards to the child. And he did say that would be great to allow him, since he has not been able to talk to the child because of the stay away order, it would require him to talk to the defendant. And all he's asking for is telephonic communication so they can make arrangements to exchange the child.
Okay,
Your Honor,
Mr.
my-
Bethel, go ahead and approach, sir, the podium.
Your Honor, just so that the court is aware, my client is not inclined to do that. She believes her thing is that Mr. Bethel has been abusive. Anytime that she's talking with him, he's abusive. He calls her names. He threatens her.
I hear
and
you.
she does not wish to do that.
I hear you. So let me make this suggestion, and if you want time to talk to your attorneys. So what I'm, the only thing I would consider, and obviously I need to ask some questions before I can, make any decision. But based on what I've heard so far, it seems the only contact that could be appropriate is contact through the Talking Parents application. So Ms. Munnings, you probably don't know what it is. I didn't know what it was until I started working here. So the Talking Parents application is an app that both people that need to communicate about a child download onto their phones. And all of the purpose of the app is that all of the communication on there is via text and it cannot be deleted. The courts have access to it. No one can delete it. So it's not like a free-for-all on an email or a phone, and it can't be manipulated or deleted. Once it's out there, it's out there. It's for the very limited purpose of communicating regarding co-parenting issues. And that's that. So it is more controlled. It's used often in the family cases we deal with. I don't know if before I even take testimony from Mr. Bethel, if that's something that would make you feel more comfortable, would make both parties feel more comfortable, quite frankly. So that way, it's not like a free for all on text. It's the court is monitoring all of those communications, and they're really just for the purpose of co-parenting, time sharing. Is the child sick? When can I see the child, or I'll pick up the child at this time, or things like that. So it's only, for those things, give the child this medicine at this time. It's very vanilla, but it's very, vanilla because it's controlled and overseen. So
because of the manipulation of Mr. Bethel, because of his abusive nature towards her, my client said that she wishes that the stay away order stays in place for her safety at this point.
Okay, so so let me, Mr. Bethel, so what you're requesting is contacts because you want to be able to communicate with Ms. Munnings about when you can see your child.
No, absolutely not. Me and my daughter actually had an app, it's like a kid's Facebook Messenger app.
Okay.
That that Ms. Munnings actually had just set up for me and her to communicate about 6 months ago.
Okay.
I guess when we started going through the proceedings of the case once again, she blocked me from that app.
Okay.
To, like I said, encroach on that relationship. I really don't need to speak to her. When I talk to my daughter, she's old enough and big enough. Hey, mommy, you want to come over? Ask mommy, is it okay? Can you come over? And that's usually how we do it. We really don't need to communicate. I don't come to her house. I'm not interested with anything that has to do with her. I'm really not. My job is to continue to be a dad.
Okay.
I don't want to keep coming back and forth here and like this. I don't. It's been 3 years. Somebody has to be the adult at some point.
One moment, sir. Well, let me just ask this: has Mr. Bethel, have you filed a case in family court?
Yes, I recently just did that. I just did that.
Okay,
But that's kind of been like a mission because again, like all the courts have been closed and, you know, the automated services are really just spoke to somebody. I just got the packet and everything. So that's,
At this point, we're gonna object. This has nothing to do with the criminal case itself. We're going into family court issues. We're asking that the court, limit this testimony at this time.
okay, one moment. I don't need testimony. What I need is to make sure everyone has the information that they need. Okay. All right. So, Mr. Bethel, what you're telling me is that was not accurate, that you do not want any contact with Miss Munnings?
Yeah, that's fine. They don't wanna try to ease the situation, so we'll do things the hard way. That's fine. We've been doing it that way.
It's very, I realize again that this is a very emotionally charged situation for the two of you, but here's what I'm trying to figure out. So my job is to just figure out what the ruling is. So the prosecutor has stated they've requested on your behalf for you to be permitted, for Ms. Munnings to be permitted to have electronic contact with you at your request. But if I understand correctly, you're telling me, no, Judge, no, thank you. I don't want to communicate with Ms. Munnings. Did I understand correctly?
No. I'm saying if it's as far as the exchange of the child, then I'm fine. But
Okay.
that's it.
I don't know what that means you're fine,
The
because you came
exchange.
up and you told me that the child downloaded an app and I don't need to talk to Ms. Munnings and the child.
Yeah, because everything was fine up until you guys sent the last subpoena for the trial in March.
Okay, so here's what I'm going to do at this time. So you can have a seat, sir. Thank you so much. I mean, it's on the record, Ms. Baez. I don't believe that Mr. Bethel expressed a desire consistent with the prosecutor's request. So I find that there is no motion, that issue is a moot point at this time. Anything further from the state?
Nothing further from the state, Your Honor.
Anything further from defense?
Nothing further.
Okay, all right. Thank you everyone for your patience this morning. You're all excused. You're all free to, well, you're not excused from your subpoenas. You are still all under subpoena for the next trial date, which is why I asked you all if you were available. You're gonna hear from the state. It's gonna be sometime, I believe, the week of July 12th. If it's not for some reason, you'll hear from them. What I meant to say is you're free to go for the day, but please understand that you're still under that subpoena for the next court date, okay? Thank you so much.
Your Honor, just a quick point of clarity. Do we have a ruling on whether they can be placed on standby and just show up on the actual trial date as opposed to having to show up here, like on jury selection day and things like that?
Well, they can appear on Zoom on jury selection day.
I thought then we're gonna have in person as in everyone will be here the morning of jury selection to check in, and then that's when we're going to the next day. How we usually like it's pre-COVID.
Okay, so and then pre-COVID, didn't everyone appear in court on Monday?
Correct. And
Okay.
Pre-COVID, the procedure normally was they've already checked in for a trial date and then placed on standby for the future trial date.
Okay, so everyone definitely is confirming that. So here's what I'll do. Because I have you all here and you've all confirmed you're gonna be in town, I understand Sergeant Rogers won't be in town until July 13th. With that exception, because you're all here, you've all confirmed you'll be in town that entire week. If the trial is in fact, you get confirmation that it's going to go forward that week of July 12th, then yes, you can just be placed on standby. You will not need to check in with us that Monday morning. If, however, the subsequent call you receive is, the trial date is actually changed and it's anything other than sometime the week of July 12th, then you all will please need to report whatever that other Monday is to make sure that you're all available, okay? All right, thank you all so much. I see a lot of head nodding yes, so thank you all so much. You're all free to go for today. Have a good day. We are off the record.